Welcome to the August 27th, 2024 Zoning Board of Appeals meeting for the town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I am now going to do a roll call. David Murch.
Tom Hennessy.
Greg Dean.
Pete Lockwood.
Fred Miller.
This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you are unable to see or to hear. The board works from a published agenda and will be considering tonight's items in the following order. Excuse me. Call to order. Number 2, approval of minutes from September 26, 2023. Items 3, new business. Election of chair and vice chair for fiscal year 2025. Administrative appeal, re 36 Merch Landing Road. Then code enforcement officer communications. Finally, adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeal rights, and also as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual right to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to stand at the microphone, to sign the speaker's sheet, state their name, address, and affiliation with the application, being either for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chair. This meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside the meeting room. Next up is approval of minutes for September 26, 2023. If there are no corrections, the minutes are approved as distributed. Next, election of chair, our new business chair and vice chair for fiscal year 2025. Do I have any nominations for chair?
I'd like to nominate David Murch.
I'd like the second.
Any other nominations? Okay. I will accept that nomination. Thank you. Do I have a motion?
So moved.
So moved. I gotta have it clear on that one. David Murch as chair for that.
Okay, so move to elect David Murch as chair.
Do I have a second?
Second.
Any further discussion? All those in favor? Pass unanimously. Next up, nominations for our vice chair for fiscal year 2025. Do you have any nominations?
Nominate Greg Dean.
Any other nominations? Greg, you willing?
Yep, I'll accept it.
All right, I will make a motion that we move forward with Greg Dean as vice chair for fiscal year 2025. Do I have a second on that?
Second.
All those in favor?
I guess I'll vote for myself.
It's legit. So approved unanimously. Excuse me. Next up is our administrative appeal for 36 Merch Landing Road. Applicant Karen and Bill Burke. Location 36 Merch Landing Road. Owners O'Connor. Description, administrative appeal of a permit for a second dock, permit number 202-4146. Assisting tonight for the ZBA is Attorney Hamer. Attorney Hamer, we have been through several administrative appeals, but it's always helpful to have guidance for properly move forward with next steps. So if you want to outline for us what that will look like tonight, we have obviously our code enforcement officer here with us. We have the appellants and their legal representation. We also have the owners in attendance of the property with legal representation for them as well. So it would be good for us as a board to know when it's appropriate for each of these parties to speak, and again, guiding us through the proper steps forward with this appeal.
Good evening. My name is John Hamer. I'm an attorney from Rubin Winchell, and I'm happy to answer any questions you have as they come up. Just wave to me, and I'll jump in. In terms of the procedure to go forward tonight, generally the procedure is that you'll hear from the person who has filed the appeal first. They present their case, followed by any adverse parties who might want to speak in rebuttal, and then hear from the code enforcement officer. Usually that's last, but it's up to you on how you want to proceed. Some boards have the code enforcement officer present the issue up front and then turn it over to the parties. But for the most part, you want to hear from the applicant first, and you open it up to parties who are opposed to the appeal, and then get this code enforcement officer's viewpoint. And you can go back and forth as necessary until you get the whole story out.
So I appreciate that, thank you. One of the things that's a little different for us is obviously this is a public hearing, so we'll be open to public comment in regards to the owner of the property. How do they need to wait for the public comment period, or are they allowed to speak in conjunction, or as you laid out in sequence with the other parties here tonight for the appellant as well as code enforcement?
The owner of the property, I would say, am I unmuted? Yeah, okay. The owner of the property is a party and is separate from the members of the public. So they're not required to wait for the public hearing. A lot of times you'll have a lot of back and forth between the two parties before you open it up to any other members of the public who wish to speak. But they do have the right to speak. They are a party as opposed to a member of the public.
Okay, thank you, appreciate that. Gentlemen, do you have any initial questions for our attorney?
Nope.
Okay, very good. So I'm going to start out, I want to ensure that we have, it's okay for us to be reviewing this this application, this appeal request. Part of that is, do we have proper jurisdiction? Having reviewed the ordinances, I don't see any question that we have jurisdiction over seeing this. Does anyone on this board find otherwise? Okay. Is there anyone on this board who may have a conflict of interest or personal bias with regards to this case?
Yes, David, I would just like to mention that my parents have worked with Murray Plum and Murray in the past. In particular, Peter Plum was their attorney for their will and testament, and I was executor of their estate. That business is complete and has been for a couple of years, but I just wanted to disclose that.
Okay. The appellant parties, do you have any concerns with this?
We do not, thank you.
Okay.
And nothing from us either. We trust there won't be an issue.
Okay. Chris, you okay? Yep. I'm okay with this. Rest of the board, you okay?
Yep.
I don't think there's any need to vote then. Standing, let's see. The standing, if the board decide have the authority to review the application, it must decide whether the applicant has standing to apply or to make the appeal. Again, having read the appeal, I believe they have standing. They are abutters. They have made a case for us to review this. Does anybody feel contrary?
No.
And Sandy is not here, but my assumption would be, Chris, that if appropriate fees hadn't been paid and this hadn't been filed properly, we would not be meeting on it tonight.
Correct.
Would that be correct? Okay, very good. Application was complete in its submission, at least as far as I can see. Do we have any disagreement with that?
Nope.
Okay, so I believe that moving forward, we have the right and responsibility to be reviewing this case. So, if I understand correctly, Attorney Hamer, we should be hearing first from our appellants with regards to this case.
Yes, there is. And the threshold issue, which you'll be hearing from the appellants, is a question of whether the appeal was timely filed.
You're right, I missed that. You know what? I knew that was a big one, and I jumped right over it and not even thinking. So, How best do we do this? It's almost like it's like two little mini cases. How do we properly move forward with this without, obviously we don't want to trial this, we don't want to go through this case in too greater detail if we're not going to really be hearing it in full. So what is your recommendation how we move forward with this?
I suggest that you have the applicant address the question of timeliness first and allow the opposing party to respond and just deal with that issue first. And if there's a decision that the appeal may proceed, then you can go on to the merits.
Very good. Thank you. So, our party for Karen and Bill Burke, or Mr. McDonald, Attorney McDonald, correct?
Yes, thank you so much. I do see a pad here. Do you want me to?
Yeah, I'll have to have you fill it out. And if you can just state your name and your residence and your affiliation for opposed or neutral with regards to this.
Absolutely. My name is Kelly McDonald. I am an attorney at Murray, Plum & Murray. I'm here tonight representing Karen and Bill Burke, who are here with me, who are the appellants in this action. Perhaps I can finish filling this out in a minute, and I will do so.
Yeah, that'd be fine.
First of all, thanks for taking your evening to consider this. We appreciate it. So going by the instructions from the chair, I'll first address the question of the timeliness of the appeal. So just by way of background, the ordinance, no question, provides for a 30-day appeal window from the date that the permit was expired. I don't think that there is any quarrel that our appeal was in fact sent in 3 days after that appeal period expired and received on the 4th day after the appeal period expired. Raymond's ordinance does provide a good cause exception. This board has the discretion to conclude that good cause exists to permit an untimely appeal to go forward. And I'd like to explain to you why I think that is entirely appropriate in this circumstance here tonight. So, by way of background, Karen and Bill Burke do own the land next to the O'Connor's property, and this is an appeal of a permit that was granted, erroneously we believe, to the O'Connors to install a second dock on their property. This precise question had been of concern to the Burkes for several years. In fact, they had gone to the town of Raymond's code enforcement officer several years ago and asked, is it possible to put a second dock on this property? And they received the answer that it was not, because it did not have enough shore frontage. And then they went to the next code enforcement officer, the immediate predecessor to Mr. Hansen, and they asked him the same question. Is it possible to put a dock on this property? And the reason they were asking this question, the dock, that piece of property was for sale. They were considering purchasing part of it in order to ensure that a dock was not placed close to their house. Based on those answers that they got, that a second dock could not be placed on the property, they decided, of course, they decided not to do so. When the O'Connors purchased the property, the Burkes met them for the first time in May of this year of 2024, and the O'Connors indicated to them that they were investigating putting a second dock on their property. And I believe it was Ms. Burke who met with them that first time, who met with Ms. O'Connor, and immediately said, well, I don't think that's actually allowed under the ordinance because you don't have enough shoreland frontage. And we've checked in with the CEO, and that's what we've been told. Concerned about that conversation and that expressing that potential that they might install the second dock, Bill Burke called the town office shortly thereafter on May 29th and left a detailed voicemail for Mr. Hansen expressing concern that the O'Connors might file an application to put in a second dock and stating that it was Mr. Burke's belief that that was not possible due to the amount of shore frontage that was available, and also repeating the fact that he had received that assurance from 2 prior CEOs for the town of Raymond. He didn't get a response to that voicemail. So he called again in the middle of June and left another detailed voicemail expressing a concern about that an application might be forthcoming. And he didn't get a response to that. And so then he went in person to the town office on July 1st to meet with Mr. Hansen to again express his concern to try to ward off any permit being erroneously issued. He was told that Mr. Hansen was on vacation, would return, and would be available for a meeting. The first available date he would be available for a meeting was July 9th. So they scheduled a meeting with him for July 9th, and in fact met with Mr. Hansen on the afternoon of July 9th. And it was at that point that they learned for a first time that an application had in fact been made for a second dock, and that a permit had in fact been issued. At that conversation, Mr. Hansen was not sure what the date of that permit was, when it had been issued, and when that 30-day window was going to expire, and so they asked for a copy of the permit. Mr. Hansen, it's my understanding that Mr. Hansen also pulled up the GIS system for the town and measured the shore frontage distance and said to the Burkes, yes, you are correct, there's not enough shore frontage there. There may have been a mistake. So it is July 9th in the afternoon. That evening, they received a copy of the permit. They then reached out to me, immediately engaged me. It did, I'm afraid, take me 36 hours to get fully up to speed and draft the notice of appeal and send it by overnight mail to the town. So on the afternoon of July 11th, 2 days after they found out, and 3 days after the appeal period had in fact expired, we sent that notice of appeal off to the town office. And it was received the following day, Friday, the 12th. And so why does that constitute good cause? Well, in order to answer the question of what is good cause, we have a lot of case law to rely on. The most recent important case is the Viles case. And in the Viles case, which was a case decided by the Maine Law Court, the Maine Supreme Court, in 2006, the law court was considering, this is Viles versus Town of Emden. And in that case, the law court concluded that in circumstances very similar to those here, a delay of 5 months after the permit was issued was acceptable and was justified good cause for the board to extend the deadline because, for a couple of different things. First of all, the abutter hadn't received any notice that the permit had been issued. When the abutter came back to their property and saw the construction occurring, they immediately took action and raised their concerns. And in fact, the permit was issued in error. And for those, in those factual circumstances, the law court said, yes, good cause exists there, even though you're 5 months after the appeal period expired to allow that appeal to take place. In that decision, the law court set forth a bit of a test. It's not a binary test. It's not an easy test. It is really a factually based test. And what the law court said is that boards should consider a variety of factors. Some may apply to a specific case, some may not apply. And so some of those factors that they listed was notice received by the abutter, how long did the appellant wait after getting actual knowledge that the permit had been issued, did the municipality violate its own ordinance, and did the abutter violate the permit they were issued. But it made clear that not all of those prongs are necessarily to be considered. You don't have to meet all of those tests in order to find good cause. So in this case, it's our view that that the facts here support all of those prongs in terms of finding good cause. It's hard to imagine abutters being more on top of the issue than the Burks were. They were proactively calling the CEO in the years before the O'Connors even purchased the property. They immediately let the O'Connors know that it would be a violation of ordinance to install a second dock. They made repeated phone calls and visits to the town office. They met with Mr. Hansen as soon as he was available, and that date was after that appeal period had expired. So it is hard to imagine what good cause is if it is not these kinds of circumstances. The law court said in Viles, the good cause exception was designed because the lack of a notice requirement, and of course there's no requirement that the town notify the Burks of this permit, the lack of a notice requirement may mean that an abutting landowner does not learn of a permit until the time period for appeal has expired. So we have a good cause exception, there's a purpose for it, and we suggest that it should apply here. Now, the O'Connors, through counsel, submitted a response to our application, arguing that this board should conclude that we're out of luck, we're untimely, we waited too long and dragged our feet in filing our appeal. Let's talk first about the law that they cite to. They rely heavily on a case called Brackett versus Town of Rangeley. That's a Maine law court, a Maine Supreme Court case too, but the key thing about that case is it's from 2003. Viles is from 2006. So Brackett is old law. And they cite to a case called Tebow versus Town of Newfield, in which this trial court, not the Supreme Court, decides that an abutter had not shown good cause. That case was decided under the Brackett standard, the 2003 standard. At that point in time, Viles had not yet been decided. Now, once the Tebow case made it up to the law court, Viles had just been decided. It was decided in between the lower court's decision and when the law court reviewed it. The law court affirmed the lower court's ruling in what's called a memorandum of decision, a MEMDEC. A MEMDEC is not law that you can cite to. It does not create precedent. The law court issues two different kinds of decisions. Normal decisions are cases you can cite to as precedent. MEMDECs are not. And in that MEMDEC, the law court said, yeah, the Superior Court weighed the factors that we laid out in Viles in this new test, even though they were citing to the Brackett test. So even after applying this new test, we're going to affirm the lower court's decision. But that's not the situation here. The new law is Viles, the new test is Viles, and I think it's notable that in the opposition that was filed, you're not going to find the word Viles anywhere in there. They don't address the current state of the law in their opposition. And I think the key difference, why does that matter? The key difference is that under Brackett, it uses the word and. You have to meet all three of these prongs, including that the permit holder violated their permit. Viles does away with that. Viles says you consider all of the factors, including whether the abutter violated the permit. But you don't have to consider that factor. So they're citing to old law. We cite to the new law. I do want to just follow up. There are two statements that are made that I think are just mistakes that were made in that opposition. In the O'Connor's opposition, they write, once they were put on notice in early June that the application had been filed. You'll find that line somewhere in there. And that's just wrong. That's not the case. They weren't put on notice in early June. They in fact hadn't gotten a response from the town. They weren't told by the O'Connors that an application had been filed, even though the O'Connors knew, as you'll see from their council submission, the O'Connors knew that the Burks had expressed this concern by left voicemails for the town. The O'Connors didn't tell the Burks that the application had been filed or the permit had been granted. And the town didn't tell the Burks that the application had been filed or the permit had been granted. They didn't learn any of that until the meeting with Mr. Hansen on July 9th. And then they state the appellant still delayed another 3 days before taking the simple step of filing the notice of their appeal. First, it was actually 2 days. It was less than 48 hours. I was on vacation. I still got it done in 48 hours. And even if it had been 3 days, we're going to suggest to you that is completely reasonable to file a notice of appeal within 3 days and only 4 days after the appeal period had expired, especially in light of the Viles decision in which the applicant was 5 months after the appeal deadline had expired. So that's what I have to say about the timeliness issue. I'll have more to say on the merits of the appeal, and I'm happy to answer any questions that you might have for me at this time.
All good, gentlemen. Do you have anything at this point regarding timeliness?
Mr. McDonald, I just had one quick question, and it's just a reminder, I think it's just a typo. On one of the letters that was submitted on June 11th, it's page 2 in the last paragraph. It talks about, it's actually in, I think, the second or third to last sentence. It actually, he told the applicants that he had made a mistake in issuing the permit and that he could call the O'Connors on June 10th. Was that supposed to be July 10th?
It sure is. It sure is. That is absolutely a typo. It's my understanding that Mr. Hansen, this is during the meeting on July 9th, and he said that he would call O'Connors the following day, which would be July 10th. So thanks for pointing that out.
Sure, that's what it sounded like. I just wanted to make sure.
Appreciate that.
Yep.
I think we're all set from
Okay.
that.
Thank you.
The O'Connors or their representative would like to speak.
All right, good evening. Good evening, everybody. Jason Howe with Preddy Flaherty. I'm here on behalf of our clients, Dan and Kathleen O'Connor, not O'Connell, to be clear. I appreciate Kelly's take on the facts. I think we come down in a slightly different place. I think as you see laid out in the memo that we submitted, the feeling is that our clients did everything they could to play by the rules here, everything that they could to play by the book. After that initial conversation with the Burks, they reached out to the town code enforcement officer and said, what do we need to do? Is this something that we can do? Can we build a dock here over on this portion of the point of land? And after a meeting and a conversation, the response was, yes, this qualifies. Our folks, of course, went forward with planning for the installation after hearing from code.
Please go ahead.
Sorry, it's really distracting to hear you guys talking, so.
Sorry.
Okay. Sorry.
I'm sorry.
In any event, notwithstanding the attempted recording, our clients reached out to the code enforcement officer and got word from code that no, in fact, they were entitled to install the dock on that portion of the land. No one was trying to hide the application from anybody else. Our clients, as you'll see from the memo, repeatedly offered to have the Burks come over and see where they were planning to install the dock at one point in the process. In fact, they did come over and see where our clients had said they were planning to install the dock based on approval from the town. We take a little bit of an issue with the notion that somehow, as Kelly insinuated, our clients were trying to hide this application from the Burks. Very much not the case. They had sought input and asked them to come over, had asked to be neighborly, wanted to show them where they were going to install the dock, wanted to make sure it wasn't going to be too close to theirs, even though the Burks dock is right on the property line. Our clients were willing to move it further away. The reality is that you can't, there's a little cove there if you're familiar with the property, and you really can't get boats inside that cove because of the rocks and things. So the dock that they had the permit to install is located out further on the point, which of course is closer to the Burks. In terms of the timeline, it's clear that yes, the Burks reached out several times to the town and talked with the O'Connors several times about the dock. It's apparent to me that if there was that level of concern, that the request should have been made to town and to code, because a request calls to planning and calls to code certainly could have asked for a copy of the permit if that were the case. And that didn't happen. We're led to believe that the first time they're aware of this is on July 9th, which is a few days after the permit the deadline had expired. But there was a continuum here. And we should also pay really close attention to the equities. You know, what's fair here? We're not trying to like pull one over on anybody. We built based on a permit that was at the time properly issued. The construction of the dock, which is a very expensive dock intended to be able to support, our clients' parents who are elderly, didn't happen until after the expiration of the appeal period. You know, the clients, as you should, waited until the appeal period had run before they started construction. And it wasn't until after completion and after a visit a few days prior by the Burkes that there was an appeal. This is not my client's position, but it seems evident to me that the issue here is not the second dock. It is the location of the second dock. If the second dock were on the other side of the property, completely out of sight, I tend to suspect that we wouldn't have the appeal today. That's just me. That is not my client's. In terms of talking about current case law, I think it's a bit disingenuous to cite that the MEMDEC decision came after the Emden case or the Viles case and then say, but that doesn't count, right? In terms of sequence for time, what the what the law court in Viles said was they recognized the test from the prior cases. They looked at bracket and they said, this is one of the tests that is used. All of these tests that have been used in the past revolve around weighing the relative equities. When you think about the case in bracket versus in Viles, in the Viles case, and I'm sure Kelly omitted this, benefits his clients, but we should be clear, the town of Emden did not have an appeal deadline. The town of Emden did not have an appeal deadline. The court imposes a reasonable deadline, usually construed to be 60 days based on some of the case law out there. But in the Emden case, there was no 30-day appeal period under ordinance. Also in the Emden case with Viles, there was no construction yet. One of the things that the Viles court talks about is the relative equities and whether or not construction had been commenced. Because in that line of cases where you have a construction permit that's issued, the old tests revolved around what was fair. In fact, if you go back to the bracket and then to the Tybalt case, again, affirmed most recently by the law court, you will see the Tybalt case say, given the exception that they're seeking in Tybalt to allow for an appeal after the fact, after the deadline has run, would be to create an exception that swallows the rule. This is a case that is very much in line with Tybalt. And what Viles doesn't do, Viles does not overturn bracket. It says there are various tests that apply, all of them centering around what's reasonable and fair. The other thing that's worth noting that's different between the Viles case and the bracket case is that in the bracket case, there was a denial of the hearing, basically that it was untimely. The board at the time said, untimely, you don't get to have a hearing, go to the court, try it at court. In Viles, it was flipped. In Viles, the challenge was coming as a result of the board having said, no, thou shalt issue a stop work order. That's not our situation here. There's no stop work order. The work's completed, commenced after the deadline had run and completed as proposed by the permit, meaning that our clients reasonably relied on the permit from the town to construct this thing after having gone through the proper channels. And if you look at the case law, when you talk about weighing the equities, a lot of the construction case law, again, bracket and Tybalt, talk about what is fair. And a lot of those construction cases tie back to whether or not construction has been commenced. Because, as you'll see again in bracket, which again is still good law, you'll see that the court says it's unfair to penalize somebody who has reasonably relied on a on a town permit for something that wasn't their fault, to then have to try and rip it out after the fact. And of course, if you follow that down to its logical conclusion, effectively what you're saying, if you buy the argument, is that, yeah, we'll allow the appeal. If the appeal goes against the person who built the dock, all that's going to happen is you're going to be back before the court with an equitable estoppel argument. And I think the law court recognized that that's not an appropriate result, because then the town is stopped from removing it, or the town ends up paying for all of the costs and damages of the installation or the rip out. So it's a bit unfair to say that you're comparing apples to apples. This is really apples to potatoes. In this case, we're much more analogous to Tybalt. We follow the bracket test, yes, but I think even if you were to weigh the equities here, if we want to lean on equities, the equities here, given the case law, suggest that you don't require somebody to pull out a dock. And that ties to timeliness, because what's fair? If the dock has already been completed or the structure's already been completed, and there's an appeal after the fact, after the deadline, unlike Viles, where there was no deadline and no completion, then the parties who followed the permit shouldn't be required to go through the process of a hearing. I think it's safe to say that we feel that the board tonight should, with respect to everybody, say this is untimely. The appropriate venue would be for Kelly to file a Rule 80B appeal, and for this board to say that based on the equities here, the application is time barred, and let the Superior Court sort it out. That's, I think, procedurally what makes the most sense to us. But this is not a case of anyone trying to hide information from the other. If anything, it was quite the opposite with our clients, trying to make sure that everything was above board, everything was done to the letter, in a fashion that was timely. No one was rushing the construction through. Everything was done as permitted. And it's only now after the fact that our clients, who have been above board all along, are stuck defending an appeal that was untimely. Happy to answer any questions if you have them.
I've got one.
Greg?
I think I may have just answered it, but I was going to ask you, it seems like a central point to your argument is this is a Viles versus bracket test discrepancy. And am I right in understanding that as you've written, that the bracket test is the enumerated in
Page 2.
page 3?
Page 3 of our.
Page 3, okay.
Yep. Page 3, second from bottom, is the test.
Yeah.
And I think that if you look at, I don't have the Viles case, Kelly may, but if you look at the conclusion to Viles, it calls out the bracket case as one of the lines of analysis. It doesn't overturn it. It just says this is one of the lines of analysis that has been used in the past. The touch point in all of this is to look at the equities of the situation. And if you look at the case law that they rely on, not addressed in Viles because it wasn't the fact set, is that in instances where the parties have built in compliance with the permit, which is what bracket's getting at, by the way, but in instances where parties have built in compliance with the permit in reasonable reliance on the permit that was validly issued in the appropriate time frame, having done nothing wrong, you apply a test that favors the party who's being challenged because they followed the rules and are now after the fact being penalized. And in those cases, the courts typically find that it's not timely. In cases like Viles, where there isn't a deadline and where the construction has not been completed. And by the way, in Viles, it was truly a vile fight between the two neighbors. It's been going on for years and years and years and years, really ugly stuff. But very distinct situation then for here. So the court doesn't overturn the test. It just says, look, we use different tests. They all sort of weigh the equities. And I think the distinction is more along the lines of what's fair here in terms of timing, certainly given the completion of the project.
Sure, I agree.
Yeah, again, not being an expert on the case law, could you just summarize the what was the dispute of the bracket case in terms of property? What was the permit for?
Building a house.
A house?
Yeah, it was building a house.
Okay.
In the bracket test, the question was whether or not you could build a house. And in the bracket case, there was the person who was building the house built it in the wrong place, at the wrong size, the wrong time, hadn't followed a bunch of shoreline setbacks and wastewater treatment procedures, which is where I think you get the compliance with the permit language that comes out of bracket. But again, very, very different circumstance in allowing that rule. And the other point in bracket too is, the notices had required hearings, and they didn't in bracket give them. So here we're in compliance with the letter of the law.
I got a question.
Yeah, go ahead.
Was there no possibility of replacing the floating dock with the fixed dock at the floating dock location?
I'm so glad you asked that.
That's what I...
Yeah, we're not at the merits, so I don't want to be premature. But the other thing here is that, as you'll see in our argument, if you read our memo, we touch on that point, and that is that there is nothing which precludes the board from simply saying that CEO has to add a condition to the permit which says you shall not dock boats at the, I've been calling it the weird boxy structure. It's probably the wrong technical term, but it's basically like a railroad tie construction in the water from which a jumping dock comes off.
Follow-up. So has the floating dock been removed now? And,
It's in the process of being removed.
and then it's never coming back? Is that
It
what
could never come back,
I think we can get into this if we.
but that's the merits. Yeah,
Okay.
yeah. That's really if you.
Okay.
Yeah.
I heard you say big boulders and rock native
Yeah. Well,
had to move.
If Kelly has a chance to hold up his diagram later on, you'll see that there are rocks that prevent access to the interior of the cove, and that the dock that's there now, as permitted, comes off of the point where you can actually get a boat up to the dock. So, but Tom, that's a great question.
Any other questions? Okay, very good. Thank you. Chris?
I'm going to reserve most of my comments if you go forward with the appeal. But I would like to say a couple things. And they're in general about the Burks, the O'Connors, and the communication with me about the dock permit and what I issued. And I'm not going to get into extreme detail because if you go forward, I'll provide more. But what I would like to say is both parties have been a pleasure to deal with their projects. I dealt with the Burks for a number of years while they built 2 cottages, tore down existing buildings, and their passion for preserving the environment in the lake was extraordinary. And I appreciate that. The O'Connors have bought a property abutting the Burks, which I would say the exact same thing. The Poulins, prior to the O'Connors, tore down a home, built a new $4 or $5 million home. I'm not sure what the price was, but it was extraordinary in that they took extreme care to protect the environment. Both parties are very conscious about Sebago Lake and preserving the lake. They both have the right to have peaceful enjoyment of their properties. They both have large properties. This dock, I think there's some miscommunication on all sides. I met with the Burks about a permit that I issued. Their concerns were at a time when I was absolutely underwater with permits and inspections and trying to keep the office afloat. I was caught by surprise that they were concerned that I issued a permit for a second dock. I didn't. If you look at the permit, it says for a new dock. In the conversations with the O'Connors and Lois O'Connor, the real estate agent that represented them in their purchase applied for the permit with Mr. Burke and I believe your son. Am I right? And during that discussion about getting the permit, it was discussed that the dock that they had was not functioning because the water was too shallow. There were too many boulders, there was too much wind, and they were getting complaints from the neighbors about the clanging of the dock. And it was my understanding that when I issued this permit, that dock would be removed. And that the permanent dock that has been discussed as a permanent dock by previous code officers, I would say that's their interpretation. My interpretation is that there was a landing. A landing isn't a dock. A landing is a place where a dock anchors and goes into the lake. This railroad tie structure that Mr. Howe described has been there for hundreds of years. Thus, Murch Landing Road. There used to be a dock attached to that went all the way out past those boulders, and steamships used to land there to bring supplies into that section of town. We have landings that used to be off from Wharf Road. Same thing. There was rock structures built with piers and wharfs, and the steamships would stop there at Wharf Road, right by Raymond Beach, and brought supplies in. So there's a lot to this. And I can tell you right now, this permit, I spent about 10 minutes issuing this permit. I don't have time to read all these law cases about whether I should or I shouldn't. And in my mind, this is a simple dock permit to move it to a location on their property that works. I mean, they could have put a dock from where it is now all the way over there, 500 feet. They could do that, and they would have no argument, because you can have a dock for whatever length you get to water where you can anchor your boat and use it. It's very shallow there. It's very rocky there. So I just think there's a lot of miscommunication, and I'm very sad that these two people that are sitting here tonight with attorneys paying all this money over something so simple that they could have worked out together. And I just am having a hard time that, you know, like I said, we have a big lake. We have big landowners here, two abutters that I wish should just get along and make the dock work for both parties. That's all I'm going to say.
As part of the information that you provided to the ZBA, you listed out a timeline. In that timeline, we have July 9th, meeting with Bill and Karen Burke and inform them that the permit had been issued. That was on July 9th. Can you confirm then that that is the first time that they were aware that a permit had been issued?
I can't confirm when they knew. That would be my knowledge of when they knew.
So the first time of being informed by the code enforcement officer?
Correct. The messages that maybe they left, I didn't receive, whether I was on vacation, whether they went to Alex's old email. We've had a lot of movement in the office, and things have changed around. I'm a one-man band instead of two people, so things got lost in the shuffle, and then I was on vacation, and then I was out with COVID, so there's a lot of different things here that come into play. So whether the permit is timely or not, it's your decision. And then we can talk about whether they should have got their permit or not at a later part of this.
I have a quick question for Chris.
Sure.
I know certain permits require notification of abutters, but I take it a dock permit doesn't.
Even a single-family home doesn't require that.
Doesn't? Okay.
Anything that goes to the planning board, appeals board, abutter notices go out, but not a simple code enforcement permit. Typically, they're issued, and once they're issued, people rely on that, and they have a 30-day period where there's the appeal period, and if it goes beyond that, they have every expectation to think that that permit is valid.
Got a question? Just for the record, I think in the attorney for the Burks, he explained several different dates for the voicemails occurred, and then 2 in-person meetings. One, I think you're on vacation. The second one, you met in person, kind of reviewed things. Is that generally your recollection, kind of late May, voicemails, and then?
I can't confirm any of the voicemails.
Okay.
I tried to do a search. I didn't find any voicemails that came to me. Whether they did or they didn't, they got lost. Whether they went to the wrong person or the wrong email, I don't know. But I can tell you that the first time I met with the Burks, we did talk about having 2 dock permits. I did do measurements on, and I said, oh, they can't have 2. But the question wasn't whether they could have 1, it was 2. I didn't issue a permit for 2, I issued a permit for a new dock.
So the first interaction then with the Burks was that July 9th in person?
Correct.
Meeting? Okay. Thanks.
Any other questions for Chris?
This is a removable dock, right? I mean, this is not a permanent dock put in.
Both are temporary docks. They have to come out December 1st of every year.
Attorney McDonald, a bunch of information has been gone around. I give you just an opportunity to to respond to any of it quickly.
Yeah, thank you so much. Kelly McDonald here for the Burks. Just a couple of quick notes in response to Attorney Howe's comments. So, as your question just acknowledged, Mr. Miller, these are in fact temporary docks. And so when we're talking about equities, we're not talking about digging a hole and pouring a foundation, right? We're talking about docks that are designed to be taken out. I also want to point out that construction did not start until the 10th. And actually that's why I suggested to my clients on the 9th, call your neighbors right away to let them know that you are going to be filing this challenge of the permit. So they were put on notice of that prior to that. I'm not even going to say construction, the installation of the docks going in the water. The only other legal point I want to make on vials, the suggestion was made that there was not a deadline to file an appeal. It's true that there is not a deadline in that town's ordinances, but what the court does when that deadline is missing, it automatically imposes a 60-day deadline. So there was in fact a deadline. It was one that is imposed by the courts instead of written into the ordinance. And when I talk about them being 5 months past the deadline, they were 5 months past that 60-day appeal window. So that's all I have. Happy to answer any additional questions that you might have.
You go real quick. What was the permit for in vials?
For a house and an attached garage.
Okay.
Mr. Burke just corrected me, and I want to pass that correction along. When he spoke with the O'Connors on the night of the 9th, he did not say that they were planning on filing an appeal. You mentioned that you were considering it the following morning, the 10th, which would have been the day that the docks were installed. So thank you for that correction. I apologize to the board for my misunderstanding.
Okay. Good. Okay, thank you very much.
Thank you.
So, gentlemen, it comes upon us to make a decision as to whether or not this was a time. Oh, that would be fine. Yep, sorry.
To be clear, to follow Kelly's point through to fruition, our clients didn't know there was an appeal being filed until after the dock was being constructed, just to make that clear. I think that I've got some other things, but I think that's all that's relevant right here.
Perfect. Thank you. And I apologize for not seeing you there. So, gentlemen, it falls on us to make a decision as to whether or not there's a good cause to accept this. Our ordinances do allow for it. I did take the time to print out the decision for Viles versus Town of Ebden, cited August 31st, 2006. Of note, paragraph 11 states, in discussing the factors to be utilized by courts in determining whether there is good cause to allow a late appeal, it is useful to recall the rationale in Keating for the good cause exception. The need for a good cause exception primarily stems from the lack of notice of the issuance of a building permit to abutting landowners or persons who may be aggrieved by its issuance. Reference to Keating. Maine statutes do not require municipalities or permit holders to provide notice to abutting landowners of the issuance of a building permit. Some municipalities may have enacted notice requirements in their ordinances. See bracket. In Keating, we acknowledge the difficulty of a notice requirement. The good cause exception was designed because the lack of a notice requirement may mean that an abutting landowner does not learn of a permit until the time period for appeal has expired. Paragraph 13 goes on to state, therefore, when a court examines whether the good cause exception is applicable to a situation, it starts with determining whether the appellant received notice of the issuance of the permit. Given the rationale in Keating, lack of notice is a key factor, but it is not the determinative factor. reference to Gagne versus Lewiston crushed stone. Another factor is the amount of time the appellant waited to file the appeal after obtaining actual knowledge of the permit, citing brackets in Gagne versus Chimbrow. Still, other factors that may be appropriate involve whether the municipality violated its own ordinance and whether the permit holder violated the terms of the permits. So that I got out of Vining. In terms of the timeline, I do have too many pieces of paper. So Attorney Howe has provided an outline. He is showing a July 8th appeal deadline. The July 6th actually fell on a Saturday. So the first Monday would be July 8th. If I'm reading this correctly, I would potentially argue that the appeal deadline could have even been July 9th due to the fact that the town hall is not open on a Monday. For Chris, first at the code enforcement officer office had informed the appellants was on July 9th. The appeal was received by the town of Raymond on July 12th, which was within 3 days. Normally, an appeal would need to be filed within 30, so I would say they met a timely filing, because again, these are just my opinions. And what was filed by the appellants, while we haven't discussed whether or not the town actually did make a mistake, they did lay out compelling arguments with regards to that. So it is of my opinion anyways that there is good cause to waive the 30-day appeal requirement and move forward with listening to this appeal. But again, I put that out there for you guys to
Right,
discuss.
and Dave, I think I would just add to that, I mean, it sounds to me, in reading through the information provided, that the Burks have a long history of being conscious of what might happen next door, and that they've been trying to follow it for quite a few years. That too, I think, adds to the discussion or the argument that you're making.
So with that said, I will make a motion that there is good cause to waive the 30-day, to waive that 30-day requirement and allow for the hearing of this appeal. Make that motion. Do I have a second on that?
A second.
What further discussion should we have on this before voting?
So just, if you could re-articulate it's based off from the vials, your conclusion is based off from the vials results that you read and the timeline. Is that correct?
Yes.
And then kind of this paradoxical situation where part of the suggested standard is whether or not there was an error made, which would require us to figure out if there's an error. We don't know that yet.
Right.
Okay.
So the timeline and, of course I set it aside, I don't. So, yeah, lack of notice. They didn't know about it until July 9th.
Right.
Correct. And the timeline of waiting to file the appeal, in my opinion, they filed it very rapidly in
As fast as they could.
response to that.
Okay.
And then also in conjunction with vials, it says, so other factors that indicates here may be appropriate include whether the municipality violated its own ordinance. We have suggestion, I believe, that we need to review to consider that could actually be a part of this, and whether the permit holder violated the terms of the permit, for which we don't have.
We don't know.
Right.
Yeah. Or whether the municipality had made an error.
Correct.
Yeah. One thing that, sorry, but just, finish. One thing that I think we should consider is the standard itself that we're supposed to evaluate it on. I believe it may be worded as a grave miscarriage of justice, I think. And so I sort of fairly moved by Chris's perspective I don't know if this is a grave miscarriage of justice. Both Viles and Brackett are houses with garages, substantial stakes. I'm not suggesting that this is my conclusion, but I'm pointing it out that it may be something we want to consider. Does it meet that standard for us?
The only question I might have is maybe we should just ask our attorney if there's anything that he thinks that he's got for an input.
Mr. Hamer?
Good evening again. And yes, I do have some comments that I think might help. A lot of the case law that you've been discussing provides very good guidance, but it's not necessarily controlling, in my opinion, because none of those ordinances had an express provision saying that the board could grant an extension for good cause. Those situations, the court was imposing a judicially created exception. And so that was a little bit different. So when you have it expressly written into your ordinance that you can, for good cause, extend the filing deadline, it lessens your burden a little bit. You probably still want to take a look at the same kind of considerations that you've been looking at, such as notice and how long it took the person to take up the matter once they were aware of it, and any other factors that you can also consider. The fact that the installation has already occurred. All those things you can consider, but I don't think you need to actually go to the same extent that the courts do in creating a judicially imposed exception, because it's in your ordinance. So if you find it's good cause, you don't have to find that higher threshold of extreme injustice or whatever the language was.
Very good, thank you. Does that help, Greg?
Not really. I actually, that's more confusing than I think anything, because I think our ordinances, I'm referencing, I believe, the language from our ordinances, which I believe says there must be and if I'm mistaken, I'd happily, revise my point, but.
Yeah, so our ordinances, Greg, 357.7C1, making an appeal A. Administrative or variance appeal may be taken by the Board of Appeals by an aggrieved party from any decision of the code enforcement officer. Such appeal shall be taken within 30 days of the date of the decision appealed from, and not otherwise, except that the board, upon showing of good cause, may waive the 30-day requirements.
Okay, so there's no, so I made that up.
You read it somewhere.
I read it somewhere.
But
Yeah, it's
yeah,
part of
it's,
it.
That's fair.
it's buried in here somewhere.
That's
but
fair.
It's not in.
I
our
appreciate the
ordinances,
correction.
I think, so.
That does help.
Are we back to your motion?
As long as we don't have any more discussion. We all good? So all those in favor of waiving the 30-day requirements? In favor, yes. David?
Yes.
Yes.
Yes. See anybody, know anyone in disfavor?
Nope,
Unanimous.
no.
Okay,
Unanimous.
so unanimous. So we shall move forward with this case. Okay.
Can I say something before we?
Oh, yeah, of
go
course
to
you
the
can,
next?
Greg.
There is an issue that perhaps we should address in between this, which was the site walk. And I think we wanted to get this threshold issue taken care of. I don't know if it's appropriate to make a motion right now, but I think it's something that we should not take lightly, that we haven't seen. It seems like there are some subjective things that need to be seen. And I would encourage us to consider a site walk before we move into great detail on the actual appeal.
I wouldn't disagree. However, I do believe there's some additional information that's going to be provided in terms of photos. I wouldn't be opposed to moving forward with this case, listening to what Wade has to say, and then if we as a board decide that it would be appropriate based on what we have heard and what we have not seen to move forward with the site walk, then doing that as opposed to conditioning this appeal on a site walk prior to listening. But I put that out there as just my thoughts.
I just have a quick question for Chris, I guess. Do any of these dock installations require a post-installation check-off, sign-off, inspection?
Yes.
And-
So, there is a condition on the permit that I do a final inspection. I have not done that yet. I did do a site visit myself last week and saw the landing, the temporary dock that was installed back in 2022 for the pool-ins. That is still there, and I saw the new dock installation. So I would encourage you to do a site walk. It is something that should be done. Whether the photos can replicate that or not would be up to you.
Can we see what our attorney says under this too?
Yeah, of course we can. Attorney Hamer, is a site walk required at this point?
It's completely up to the board. If the board thinks that having a site walk would provide additional information which would be helpful in resolving the case, then I would suggest that it be scheduled first so you can take a look at the grounds and then come back and discuss it afterwards. I'm afraid that if you wait and save the site walk till after you've had a discussion about it, then you might end up changing your minds and it might be confusing. So if you're going to do a site walk, that's great. I think that's perfectly appropriate. I'm sure it's required, but it's completely up to you. If you decide to do it, though, I think it should be done first.
Okay.
Question for Sandy.
Yeah.
Sandy, when could the next site walk be
The
scheduled?
earliest you could do it is September the 14th because of having to get the notice in the paper
Yep.
twice.
Notices and,
But that would still make us make our meeting for September though, right?
Yes, it would.
and then I'm not sure I should ask this question, but do we know when the dock is gonna be removed for winter or whatever?
Doesn't need to be removed until December.
Yep.
I would wait until this all resolved before we do anything, frankly. I just
Okay,
don't
that's,
know
that's,
which room coming or going right now, honestly.
yep.
It wasn't a de minimis dock, we spent $36,000.
Could you go to the podium, please?
Sure. Yes. Good evening, Dan O'Connor, 36 Merch Lane Road. I'm sorry we're here this evening. I would have loved to have worked this out in a much different way. I invited my neighbor to do that. I just moved in. All I wanted to do is get a dock so I can get my boat into our property that we did spend a significant amount of money that it basically worked my whole life to accumulate. That was what I wanted to do. If Bill wanted, if they thought we were going to build a dock, they could have asked me. I've been there the whole time. I would have said, I'm putting in a permit. Come on over, which is exactly what I said when he told me the first time we were putting in a dock. All I need to do is try to get a boat in there. I can't do that safely. I put a mooring in anticipation of when Chris gave us the dock permit. We didn't wait 30 days because I knew there was a waiting period. I waited 30 days because it took 30 days to build the dock. And it was, again, a dock that I was trying to do that was in keeping with the property and my neighbor's hopeful expectations. I invited Bill to come over and look at the property before we put it in, and it wasn't, it ended up not being acceptable to what he wanted to see. It's hard for me to understand what to do with the dock right now, honestly. I feel like just chucking the whole thing to the water. That's how frustrated I am with this. I don't want to wait until September 2nd you're all welcome in my property anytime you want to come over, as is my neighbors, all my neighbors. But I don't want to wait until September 2nd to get a resolution on this issue. I just moved into the community. It couldn't have been off to a worse start for us, honestly. And I don't know what we did wrong, other than following all the rules and trying to keep my neighbor happy. Thank you.
Chair Murch.
Yeah.
We're going a little out of order here.
Yeah.
And so,
I'm sorry, you need to use the podium.
Yeah.
thank you, Kelly McDonald here on behalf of the Burks. So I didn't want to cut Mr. O'Connor off because I hear that he wants to speak, but we are out of order.
Correct. And
This is
let me
not-
just try and rein this in a little bit.
Yeah.
Let's just speak right now to the fact on the regards to the site walk.
Yeah.
And then we'll move from there. Are you willing to, how,
Yeah.
for the Burks, how are they feeling with regards to the need for a sidewalk?
I'm sorry, would you ask your question again, Chair?
Yeah, with regards to your clients.
Sure.
The Burks, how are they feeling in regards to the need for a sidewalk?
So obviously, we're going to defer to the board. Well, we don't have a choice on deferring to the board. You guys get to make the call. But it's my view that we don't need a site walk. This is a mathematical question. How much distance is there between the two spaces? And it sounds like the real issue is this a second dock? And I'm looking forward to talking about that when we reach the merits. I'm not sure what the sidewalk does, except gives you an opportunity to see the docks. Now, just to be clear, I don't have up close pictures of the docks in case you're hoping to rely on that. I've got like a Google map picture, an overhead showing the permanent dock that is there with the temporary dock off of it. And that picture was taken before the second dock was installed. From our perspective, the permit was filed while a first dock was in the water. Therefore, it is for a second dock. The permit did not include we've taken this dock out and we would like to put a new dock in this location. So the remedy that Attorney Howe has suggested, that this board say, oh, you're fine, just make sure you don't dock a boat on the other dock or you take the other dock out. That's not, I don't believe, before this board. Before this board is the permit that was actually submitted, and the facts in existence when that permit was submitted was there was already another dock in the water. So I'm not sure that a site walk changes the equation very much here. That's our position on the site walk. But of course, if the board prefers to, would like to do that, we'll happily arrange that and schedule it and go along.
Okay, so if I'm hearing things correctly, hold on one moment for, in regards to the appellants, they're okay with essentially, I don't want to call it waiving a sidewalk because no sidewalk is required, but your parties are agreeable to moving forward with this case without having us do a sidewalk.
Appellants are fine moving forward tonight and would prefer to move forward tonight without a sidewalk.
Okay, very good.
Thank you.
Can I make a point of order?
Sure.
In our letter to you is a motion and request that there be a site walk planned and conducted because we think it's material, obviously, to seeing the property and seeing how this is set up in making your decisions about first or second dock and in making your decision about whether or not, what the facts of the surroundings look like. It's not a mathematical equation. It's a $30,000, $40,000 equation here where we think that our clients, after having relied reasonably on the board, are entitled to have you folks come and take a look at the property and see what's there before you ask them to rip out a $40,000 dock, having done no wrong. So our request in the motion was to, or in the letter was to do a site walk.
Okay, but I would also say that Mr. O'Connor came up and indicated that he wanted the appeal to move forward tonight. So how do you reconcile the two?
Out of frustration.
Okay.
Out of frustration.
Okay, very
Because
good.
we've been living here for a month and a half
Okay.
now.
Yep.
With this hanging over our head.
Yep.
So, but I don't want to because.
Yeah, okay.
I
Mr.
want to
O'Connor,
see
Mr.
what we
O'Connor.
try to do.
Any comments are going to have to be at the podium, and I'm going to say, sir, you stay seated because we are right. There is a point of order to all of this, and I recognize your frustrations, and I understand that, definitely. But we have to follow through in a correct order.
Sure.
Chris?
So, the only reason I'm recommending a site walk is because you're being asked to determine whether there's two docks. There are two temporary docks. There's no question. There's two temporary docks. One was my understanding was going to come out. So the question that arose by the Burks with the two previous code officers were that the landing, which I'm calling a landing, is not a dock. The purpose of a site walk would be determine whether that landing, let's just say the O'Connors remove what's there and keep their dock. They have one temporary dock. To have two docks, you would have to determine that the landing, or the 12 by 16, whatever the dimensions are of that landing, is a dock or a landing. It's simple. But that you can't visualize unless you're there. It's not attached to land. You have to go across a dock to get to the landing. Then the landing is the base for a dock that extends into the lake like it did 100 years ago. So a site walk would be very helpful unless we have pictures looking down on the site to show a landing. To me, that's not a permanent dock. A permanent dock would be something that originates at land and can be used to moor and dock boats. This isn't the case. It's not deep enough. There's too many boulders there. Just saying, a site walk would be extremely helpful.
I'll put a motion that we schedule a site walk as soon as possible.
I'll second that.
Okay, all those in favor?
Do you want to do discussion?
Oh, I apologize. Yeah, our discussion will be
No, just
Just being annoying.
since you corrected me earlier, I will.
Robert's rules.
Yeah, well, we're a whole year out from doing this, so yeah, it's all good. So any further discussion? All those in favor of scheduling a site walk? Unanimous. So, Mr. Hamer, how do we procedurally move forward with this? Is this considered a tabled item until a site walk is done?
That would be my recommendation, is that it be tabled to a date certain, at which point, following the site walk, that the matter would be reconvened.
Okay. So Sandy, you're saying that we can have a site walk on September 14th?
Yes.
And the following meeting would be when? September?
September 24th. That's what I just pulled my calendar out for.
So you're saying September 14th, correct?
Yeah.
All right. Looks like we're gonna need a motion to table this issue.
So moved.
Second.
All those in favor of tabling this case until our next meeting, September 24th, following a site walk? Unanimous. So we'll meet again on September 14th.
Thank you.
Of course. And
What was the date of the,
Yeah, at 9 o'clock,
Somebody.
right? Yeah.
And Dave,
Yeah,
Somebody
Mr.
had a
Attorney
question.
Hamer?
what was the date of the next meeting?
The meeting itself, yeah, September 24, Tuesday. Site walk, September 14, Saturday. 9 a.m., correct.
May I ask a question?
Sure.
I just did. May I ask a second
Yeah,
question?
yeah, what's that?
What are the board's wishes as to interactions with the parties during that sidewalk? I just want to kind of set the expectations appropriately. How do you all usually, do you not want to hear from anybody? Do you want us making observations? Do you want to call us? What's your preference?
We are not there to essentially evolve the case any more than for us to just simply look at the property. So if there are any questions, the board members will ask me, and then I will in turn ask anybody who may be there representing the property. Outside of that, we are not looking for anybody to provide us with any information other than what we asked for.
So don't offer input until we are asked for input.
Correct.
Thank you. I just wanted to,
But note that it's a public meeting announcement, so anybody can attend.
This is correct, yeah.
thank you. I just wanted to make sure that the expectations were clear on all sides.
And I guess with regards to this, we should ask the O'Connors, this is an appeal, but it's on your property. I need to make sure that you're okay with us coming to your property. You're not considering trespassing or anything like that?
Yes.
Okay. And again, it is, as Tom mentioned, it's open to the public, so anyone will be able to come on property. Okay.
Maybe juice?
Maybe juice.
Okay. I appreciate your time tonight, and we will meet again on 14th for the site walk, 24th for the meeting. Next on our agenda, Code Enforcement Officer Communications. Chris.
Well, we have another application for an appeal that was,
Thank you.
Sandy does, yeah, have a good day.
Oh, I do know, because I gave it.
Okay, so we have another appeal that came in today, very similar. It's appeal of a violation that I issued for installing a dock without a permit and a shed without a permit on Thomas Pond on the Casco side on Shore Road. So we'll be looking to you for that in September.
Does that mean we have 2 site visits? Sandy?
Is there a potential for timeliness on this one? Or is it,
No, it was a timely appeal,
Oh, yeah,
Okay.
it's got plenty of.
plenty of time.
okay.
The only thing that isn't necessarily timely, Chris, is our filing for this meeting was on Friday, but we're gonna meet anyway.
Okay, I'm going to pause this just for 1 second. Mr. Hamer, I believe we are all set. Board, do you have any questions for Attorney Hamer?
No.
I apologize for letting you, forcing you to hang on here.
That's all right. Thank you.
I appreciate your insight tonight and your help.
You're welcome.
Thank you.
Thank you very much.
Now, we still have quite a few people logged on too, right?
Yeah, but
Yeah.
we didn't have to open it to public comment, so.
And Jason is the new code enforcement officer that was watching, and he'll be starting to attend these meetings in the next month or so, and hopefully taking over some of my duties at some point.
So the structure, is it similar to how you and Alex perform, but now essentially you're in Alex's role, sort of doing more of the?
Yeah, with Alex's departure in March, we were left with no code officer. I was the assistant. So I agreed to jump up from semi-retirement to full-time to do the code enforcement job until we found somebody. We haven't found anybody that was certified, all ready to go. So I'm in the process of training Jason Williamson, the guy we hired 7 weeks ago. He's a very quick learner, has a lot of building experience, and I believe at the end of the year he'll be able to take over as the code officer, and I'll go back to what I was doing with Alex part-time. Hopefully.
Nice.
See how that works.
That's the plan, right?
That's the plan. But it's I can tell you that it's already a relief having just somebody else to help.
Yep.
It's a lot. As you know, we've been extremely busy with many issues. Some that you dealt with and some that are just normal business. But this is not what I had planned on, but it's all good.
Yep.
I do enjoy this. It's just I was trying to calm down, ease out.
Well,
So much for
welcome back.
so much for retirement.
Yeah.
But like I said, I live right a mile from here, so it's all good.
Okay. Anything else? Anything, Sandy?
Other than, did you guys do the minutes and chair and vice chair? Okay,
Yeah,
I'll see that
we're-
when I watch it.
It's a real shocker in the beginning.
It's all the same, nothing changed.
Same-o, same-o.
Didn't I look like I was surprised by
Yeah.
that? So my issue was I got a new router for my internet, and it's telling me that I need to put in this 4 to 8 digit code that's on the thing. It's nowhere on there. I have a picture of it. There's no numbers. So I'll be having fun with Spectrum when I go home from work tomorrow.
Good luck.
Wish me luck, folks.
I've had that issue in the past. It's not fun.
No, dealing with them is not fun to start with.
So Sandy, we'll do the first site walk over on Merch Lane.
And the other one
The
I'll
other
make
one,
for
like,
10.
2 hours later or something? Is that,
Well, I usually schedule them an hour apart.
or, yeah.
How far away apart, do you know, distance-wise?
Sounds close, yeah.
You could do it in an hour.
5 minutes.
Have we adjourned?
Have 5 minutes between.
No, we have not.
No, we're still doing our communications.
But there's no issue doing it an hour apart.
Right, but I mean, the properties are not, they're not even 5 minutes apart from each other.
I mean, the only other
Birch Landing
thing,
right over to
you don't
Red
want to
Road
not give yourselves enough
to,
time at the first
Point
one.
Shores, correct?
We don't know who's going to show up on the second one because we know nothing about it yet. So it's a matter of,
I don't think a site walk's as imperative on that one, but if you want to schedule it.
no, but we normally do them.
Yeah.
the
Yeah, let's
Saturday.
let's do them an hour apart.
Yeah.
Unless you're looking and you see that it's like a 30-minute drive, which it shouldn't be, but
No,
if you're
it
seeing it's ridiculous, I
Right.
don't imagine. We've done 3 site walks in one day.
Yeah.
Yes, you have.
So, okay, and the other thing, I don't know,
So I'll
with this,
schedule the other one for 10.
with this second appeal that's coming up, multiple lawyers for this first one, I don't know how to, I don't know if it's worth advising the second appeal party that this is potential it could be later in the evening. Yes, we'll start at 7, but we may not get to them until, we can't even take up anything new after 10 o'clock.
Right.
So,
You're welcome.
Yeah.
Thank you for that.
This one could go a while.
Yeah, that's what I'm concerned of. I guess just voice the concern maybe to that applicant, just to let them know that,
Yeah.
show them our bylaws, nothing new after 10. We have no idea how long this one will take.
Right.
So I don't know if they have their own attorneys at all, so it's just, I don't want them to,
It would be nice to be able to do this without 9,000 lawyers, wouldn't it, guys?
it's okay.
Well,
Sharpens our
They
skills.
make it interesting.
Yeah, they do.
All right. All set, Chris, then? All set, Sandy?
Just need a motion and a vote to adjourn.
Yeah, motion that we adjourn.
No objections.
All in favor? Woo-hoo, we are adjourned.